Hey there, and welcome. If you're tuning in today, you're probably looking for some clear, actionable answers. Think of this explainer as your absolute survival guide to navigating and really battling the often confusing bureaucratic machine of credit reporting errors. Today, we're demystifying a very specific piece of federal law, 15 U.S.C. Section 1681I. We're going to unpack exactly what your credit dispute rights actually are. I know it can feel like you're going up against a giant, but you have very specific legal tools at your disposal. Okay, let's dive right into this. To truly understand why this law even exists, we have to look at the massive stakes involved here. As Lampin Law points out by referencing the original congressional findings, the entire banking system in the United States is fundamentally dependent upon fair and accurate credit reporting. Think about that for a second. This means your individual credit file and the errors that might be hiding inside it aren't just personal annoyances, they actually impact the stability of the entire U.S. economy. Unfair or inaccurate reporting directly undermines public confidence, which is exactly why federal lawmakers had to step in.
So here's the roadmap for our explainer today. We're going to cover 1. The power of credit. 2. Starting your dispute. 3. The 30-day investigation. 4. Fixing unverifiable information. 5. Unresolved disputes in statements. And finally, 6. Special rules and protections.
Section 1. The power of credit. Why the Fair Credit Reporting Act exists. We absolutely have to start by acknowledging the sheer immense power that credit reporting agencies hold over everyday consumers. I mean, these agencies collect massive amounts of data that literally dictate whether you can buy a house, get a car loan, secure insurance, or sometimes even land a job. Because of this overwhelming power, the FCRA requires consumer reporting agencies to adopt reasonable procedures that are fair, equitable, and protect confidentiality and accuracy. Within that broad federal framework, the specific code we're looking at today, 15 U.S.C. Section 1681I, is essentially your primary weapon as a consumer. When the system inevitably makes a mistake, this statute is the exact legal mechanism you use to enforce fairness and hold these massive data brokers accountable. Section 2. Starting your dispute. The inciting incident. Let's move on and see how this builds. This inciting incident is the exact moment you, the consumer, discover an error and decide to take action. This is where the legal machinery really starts turning. But before we look at the specific steps of a dispute, we need to define a critical term used in the law, the furnisher of information. So what is that? It's any person or entity that provided the disputed item to the credit reporting agency in the first place. We're talking about a bank, a hospital, a collection agency, maybe a credit card company. Understanding this is vital, because when you file a dispute with a credit bureau, the furnisher is who the bureau is actually investigating and talking to behind the scenes. And this brilliantly illustrates just how fast those bureaucratic gears are legally required to start spinning once you initiate a dispute. Step 1, you discover an error and you notify the agency. Step 2, the credit reporting agency must notify the furnisher of information within just 5 business days. 5 days. They can't just sit on your request or put it at the bottom of a pile. The law demands an immediate, scheduled response. Section 3. The 30-day investigation. The clock is ticking. Once that notice is sent, you enter the core trial of your quest, the statutory reinvestigation period. 30. That is your magic number. By law, the Consumer Reporting Agency has exactly 30 days to conduct a reasonable reinvestigation to determine if the disputed information is inaccurate. And a very, very important note here, this process must be conducted entirely free of charge. You don't have to pay to get someone else's mistake fixed. The clock starts ticking the very moment the agency receives your notice of dispute.
Let's map out this timeline so you know exactly what to expect. Day 1 is when your notice is received. By day 5, the agency has hit their deadline to notify the furnisher. By day 30, the standard reinvestigation absolutely must be complete. But notice that day 45 there, the agency can legally get a 15-day extension, but only under one specific condition: if you, the consumer, provide new, relevant information to them during that initial 30-day window. If you don't submit anything new, that 30-day deadline remains absolute. So the crucial point here is understanding the difference between a valid dispute and a frivolous dispute. A valid dispute successfully triggers that full 30-day reinvestigation process we just discussed. However, an agency is legally allowed to just terminate the investigation if they reasonably determine the claim is frivolous or irrelevant. Like, for instance, if you fail to provide enough information for them to actually investigate. But they don't just get to ignore you. If they terminate it, they face a strict 5-business-day deadline to notify you of that decision. And they must tell you exactly why they're rejecting it and what you need to provide to fix it. Section 4. Fixing unverifiable information. Resolution and reinsertion.
All right, we've reached the climax of the investigation. The 30 days are up, and your disputed data is either going to be verified as true or it gets the axe. Let's contrast the two possible outcomes of this process. On one side, the item is maintained, meaning it was verified as complete and accurate by the furnisher. But on the other side, the item is deleted or modified. Now, the absolutely vital thing to grasp here is that a deletion doesn't just happen if the information is proven definitively false. If the agency simply cannot verify the information through their investigation, it must be promptly deleted. A lack of proof on their end equals a deletion for you. Now, sometimes things get resolved in just 3 days. The legal code includes this really interesting expedited dispute resolution rule. If a credit agency receives your dispute, looks at the item, and simply deletes it within 3 business days, they're actually allowed to skip all the complex, ongoing notification bureaucracy. It's basically a built-in incentive for them to act fast, providing you with a rapid track to a clean report. But what happens if deleted information tries to sneak back onto your report months later? Well, the law actually anticipates this and provides strict rules for reinsertion. Information cannot just be quietly slipped back onto your file. To put a deleted item back, the furnisher must explicitly certify that the data is now complete and accurate. Furthermore, the agency must notify you in writing within 5 business days of putting it back, and they have to give you the furnisher's business name and contact info. Think of these rules as a heavy shield. They prevent what are often called zombie debts from coming back to life on your report without strict proof and immediate transparency. Section 5. Unresolved disputes and statements. The consumer's last word. Let's look at the scenario where a stalemate occurs. The furnisher says the debt is accurate, you disagree, and the dispute isn't resolved in your favor. 100. Even if you lose the investigation phase, you are not out of options. The law grants you the right to add a 100-word statement of dispute directly to your credit file. This acts as a permanent asterisk right next to that negative mark. Now, if the agency helps you write a clear summary, they can cap it at 100 words. But the point is, you get to have your say on the official record. And the agencies can't just hide this statement either. The code dictates that the agency shall, in any subsequent consumer report, clearly note that the item is disputed and provide your statement or a clear summary. This is incredibly important. It means that whoever pulls your credit file in the future, whether it's a mortgage lender, an auto financier, or an employer, they are going to see your side of the story, provided your statement isn't deemed frivolous. You ensure that context always travels with the negative mark. Section 6. Special Rules and Protections. Veterans and Federal Oversight. Now, what's really interesting about this is that the legal code isn't just a blanket set of rules. It includes specific carve-outs for vulnerable groups and higher-level accountability mechanisms to keep the agencies in check. There is a powerful, fast-track protection specifically created for veterans dealing with medical debts. Let's compare standard disputes to this protection. For a standard dispute, your notice triggers a reasonable reinvestigation. But for a veteran's medical debt, if the veteran provides proof that the Department of Veterans Affairs has assumed liability or is even just processing the payment, it triggers a mandatory deletion of that medical debt from the credit file. The standard of proof is very specific, but the result is swift, guaranteed protection without waiting around for a lengthy back-and-forth investigation. Zooming out for a second, you might wonder if this whole system is just entirely self-policed. It's not. There is federal oversight by the Bureau, specifically the Consumer Financial Protection Bureau. On a macro level, the Bureau compiles consumer complaints and transmits them directly to the reporting agencies. And the agencies can't just toss these out. They are legally required to review their obligations, address the subject matter of the complaints, and provide regular reports back to the Bureau detailing the actions they've taken. The agencies have to continuously prove they're following the exact dispute procedures we've outlined today. But as we wrap up, I want to leave you with a final, kind of provocative thought to consider. We know the Bureau handles oversight, sure, but if the initial burden of proof almost always falls on you, the consumer, to meticulously hunt down the errors and initiate this complex dispute process, who is really policing the credit bureaus day-to-day? The reality is, it's you. I hope this explainer has demystified 15 U.S.C. Section 1681I and empowered you to take control of your credit file, knowing exactly what legal tools you have to demand fairness and accuracy. Keep learning, stay focused, and definitely use these rules to your advantage.